This video, we're going to be talking about the difference between co-agents and successor agents in a well-drafted power of attorney. But I want to preface this video by stating, if you've heard me speak at an event or anywhere online, I always tell people the most important document I can provide my clients is a well-drafted, Medicaid compliant, durable power of attorney. People are often finding these forms online and they have this false sense of security because it might work at the bank. And that's very generic. You don't need a lot of specific language for that. But when we get into our more complicated Medicaid planning tools, these generic powers of attorney will often fall short. So that's just my preface, buyer beware, and know what you're getting yourself into. But now to the point, let's presume you have a good power of attorney. What we will often ask our clients is, who do you prefer to be your primary decision maker? It might be a spouse, might be a child, might be a friend. It's just anybody you trust, who you believe is going to act in your best interest, can serve as your agent under a durable power of attorney. So they'll typically give us one person, and then we'll say, okay, well, what if that person cannot serve? Maybe, God forbid, they pass away, or they get sick, or they're away on vacation. Something needs to happen. A decision needs to be made. Who gets to take over? It's always good to have at least one backup, or an alternate, or a successor agent under a durable power of attorney. And so then I get the question as well, if we're going to name 2 or 3 people to have this power, should they be co-agents, meaning they can all serve together? Or should they be successor agents? If one can't do it, we go down the line. If that person can't do it, we go down the line, right? So co is all equal, able to serve at the same time. Successor, only one person serving at a time. My general advice is I like successor agents better than co-agents. The reason is I like knowing that only one person's in charge and they don't have to worry about too many cooks being in the kitchen. That being said, this is a fluid answer in terms of family dynamics can vary. If I meet with a family, and typically let's say mom is the one who's going to be signing the power of attorney, and she has 2 children, they're both equally as active in her life, and they both get along, and everyone's on the same page. And mom says, well, I want my kids to be able to serve concurrently, then I'm fine with that, because the advantage to someone serving concurrently is if one is away, we don't have to go through the rigmarole of proving to the bank or the third party that they're not available, because we have already named someone who's able to serve, and typically it's independently. If we do have co-powers of attorney, co-agents or a power of attorney, I will rarely, I'll do it if you tell me to do it, but I will highly advise against making them have to agree in order to get something done. I want them to be able to work independently so that things can actually get done. Because if they have to agree, and again, one of them's away, one of them's just not available readily, then you have an issue where things are just not getting done because 2 people need to sign the check. 2 people need to agree to fund a trust or create a trust or do Medicaid planning. And this prevents things from getting done, and my job is to make your life easier, to get you access to benefits. If we need to get things done, I want them done speedily and efficiently, and we don't want bureaucracy within your own family. Okay, so generally speaking, my preference, all things being equal, one person serves at a time, and then we have, if that person's not available, then we have backup number 1, maybe even backup number 2. Or, presuming everyone gets along, we have co-agents who can sign independently of each other because everyone trusts each other. We're all going to do the right thing. If you want co-agents and you say, well, they don't get along, I'm going to tell you, my advice is I think co-agents is a horrible idea because they're just going to fight. And I've seen that with the powers of attorney prepared by other attorneys. A case comes to mind, we have mom who had 2 daughters, and these 2 daughters hated each other, but because mom wanted to be politically correct or didn't want to insult anyone, she made it so that both daughters are co-agents, able to work together, but have to agree before anything gets done. And I basically had to force one of them to resign. I said, I'm not going to handle this case because I can't deal with both of you fighting with each other, and this is just no way to get anything done. So one of you's got to resign because I need one person who's going to take my advice and not question everything and make mom's life easier, not more difficult. So these things can happen. Anyway, those are the differences between a power of attorney. There's lots more to durable powers of attorney. They're highly complex documents, very, very important documents, because if you have a good power of attorney, then all the planning in the world is available to you. And it's really nice to be able to, a family comes to me with an excess of hundreds and hundreds of thousands of dollars, and I have all these great ways of protecting that money without having to wait 5 years and letting their loved one protect their money, get access to needs-based government benefits, making it more likely they'll have something to pass on, but making it more likely that they're going to have a higher quality of life, because we're going to get them government benefits while having access to funds that have been protected. So anyway, I hope this helps. And if you like this video, please share it. Please give it a thumbs up. Help me get good information out to Floridians everywhere.